Families and the law. Separation and divorce. Family law in Alberta is complicated, but learning about the law that applies to your situation is a good first step. This video is one in a series that talks about different parts of family law in Alberta. This video focuses on the processes for separating from or divorcing your spouse or partner. There are different ways to end a relationship in Alberta depending on if you are married or unmarried. If you and your partner are not legally married, no court process is required to make the separation final. If you are married, the Divorce Act applies to you. This is a federal law about divorce that applies the same all across Canada. To legally end a marriage, a judge grants a divorce judgment. But rarely is separating or divorcing just about ending the relationship. There are usually other things to talk about. Do you have dependent children? If yes, you'll need to think about how you and your ex will parent together. There are two laws that deal with parenting in Alberta: Alberta's Family Law Act and the Divorce Act. Unmarried couples can use the Family Law Act, while married couples can use either the Family Law Act or the Divorce Act. You can find more information about the laws on parenting after separation or divorce in the booklet and video called Parenting Time and Contact. Do you need financial support? Child support is a payment from one parent to the other for the benefit of the children. Spousal support is a payment from one spouse to the other if the recipient spouse proves they need it. Partner support is a payment from one adult interdependent partner to the other, again if the partner proves they need it. Just like it is under the laws for parenting, unmarried couples can use the Family Law Act, while married couples can use either the Family Law Act or the Divorce Act to apply for financial support. You can find more information about child and spousal support in the booklet and video called Financial Support. Do you own property together? You'll need to divide it between you. Alberta's Family Property Act describes how married couples and adult interdependent partners divide property when they separate. You can find more information about the laws on dividing property in the booklet and video called Property Division. You and your ex do not necessarily have to go to court to deal with issues like parenting, financial support, and dividing property. There are many ways to resolve a dispute outside of court. A do-it-yourself agreement will save time and money and gives you more control over the decisions you need to make, though it is a good idea to consult a lawyer to make sure your plan is fair and enforceable by the court. You can also have a professional help you. You can work with a mediator, a neutral person who helps you work together to come up with an agreement that works for everyone. You can work with an arbitrator, a person the parties appoint to make a decision instead of a judge. The arbitrator will make a decision that is in the best interests of your children. There's mediation arbitration, where a mediator is given the power to make a binding decision if you cannot come to an agreement. And lastly, there are collaborative processes, a type of negotiation where both parties have their own lawyers but work together to find a solution instead of going to court. If you cannot come to an agreement, only then will you have to go to court. Going to court should be a last resort. In court, a judge will come up with a resolution that is fair and is in the best interest of the children. It is not about being right or wrong. It is not about punishing one person while applauding the other. You will not be happy if this is your goal in going to court. Now, let's dig deeper into the divorce process. Canada's Divorce Act says that you can only ask for a divorce if there has been a breakdown of the marriage. This can occur in one of three ways. You and your spouse have been separated for at least 1 year with no chance of getting back together. You or your spouse committed adultery. Either spouse treats the other cruelly. You should file for divorce in the province where you have lived for at least 1 year before starting the proceeding. If you live in one province and your spouse lives in another province, you might each file in different provinces. If this happens, there are rules in the Divorce Act about which court action is allowed to continue. Do you and your spouse agree on getting a divorce? And do you have written agreements or court orders dealing with parenting, property division, or child and spousal support? If yes, this is an uncontested divorce. You can file for an uncontested divorce in two ways. You and your spouse could file a joint statement of claim for divorce, or one of you could file a statement of claim for divorce and the other would choose to not fight it. You usually do not have to go to court for an uncontested divorce application. This is called a desk divorce. Once you have filed your documents, the court clerks and the judge review them. If everything is correct, the judge can grant you a divorce without you having to go to court. If you and your spouse do not agree on everything, this is a contested divorce. If your spouse is contesting the divorce, you may have to go to court at some point. However, as we've already mentioned, there are many ways to resolve issues without going to court. The process for getting a divorce that is not a joint divorce is a little more complex. One person, called the plaintiff, starts divorce proceedings by filing a statement of claim at the courthouse. There are different kinds of statements of claim depending on whether you are also applying to divide property. Then, the plaintiff arranges for the other person, called the defendant, to be served with the documents. To serve someone means to officially give them documents in a way that can be proven to the court. Someone other than the plaintiff must personally serve the defendant with the statement of claim. If the defendant contests the divorce, they must file a statement of defense. It could be that the defendant does not agree with getting divorced, or that they do not agree with your proposal for how to parent your children and pay financial support. A judge will not grant a divorce until the spouses have agreements or court orders about these issues. If you and your spouse cannot agree on parenting and financial support, then a judge will decide. Remember, arguing in court can take a lot of time and money. For both uncontested and contested divorces, a judge grants a divorce judgment that formally ends the marriage. Your divorce will become final 31 days after the judge issues this order. This is to give one spouse time to appeal the judge's order. Once the divorce is final, you can request a certificate of divorce online on the Alberta Court's website. The certificate will arrive in the mail. If you want to get married again, you will need this certificate to prove that you are divorced. Now, let's talk briefly about separation for unmarried couples. Even though there is no formal process to end a relationship where the couple was never married, there are documents you can sign that state your relationship is over. You might sign a separation agreement that outlines how you will divide your property, how you will parent your children, and who pays financial support. If you and your partner have children, but cannot come to an agreement about parenting or financial support, either yourselves or with the help of a professional, then you will have to go to court. A judge makes these decisions under the Family Law Act. Under the Family Law Act, you You can also get a declaration of irreconcilability. This is a declaration by the court that you and your partner will never get back together or reconcile with each other. You can find more information on the process of going to court in the booklet and video called Resolving Family Law Disputes. For more detailed information on this topic, visit cplea.ca/family.